Greetings to you all, and thanks for attending the press briefings today. This press briefing has been called by the African Tech Movement in Kenya in partnership with Project Ether, a continental initiative committee to the realization of safe, dignifying, and just labor marketing in technology and related sectors in Kenya and Africa. The Africa Tech Workers Movement is a continental movement that is advocating for the rights, protection, and dignity of Africa tech workers in an era where digital work is expanding opportunities for honest work for many young people in Kenya and Africa. The movement is born out of the realization that the best dividends from this job must not come at the expense of justice, fair and just compensation, human working conditions, and the dignity of workers as human beings. In Kenya, the African Workers Movement brings together several organizations, including the following: Organization of Online Drivers, Unity of Online Drivers, Data Labelers Association, Raid Hailers Transport Association, Blessed Ladies Organization, Digital Tax Association of Kenya, Digital Border Drivers and Delivery Associations, African Content Moderators. Ladies and gentlemen, the Constitution of Kenya provides clear framework for participation of people in governance, including the legislative process by Parliament. In particular, the provisions of Article 10 and Article 118 ensures that such participation by the people is meaningful, not cosmetic or performed merely for the purpose of compliance. While Article 10 outlines national values and principles of governance including participation of people, Article 118 states that Parliament shall facilitate public participation and involve the legislative and other businesses of Parliament and its committees. Despite this clear provision, ladies and gentlemen, on Thursday, 7th of August 2025, the Senate of Kenya passed a very consequential bill in complete and total disregard of the rights of public participation. Subsequently, this press briefing serves four main objectives. Number one, to condemn in the strongest possible terms the passage without public participation of the Business Law Amendments Bill of 2024, also known as the Senate Bill number 51 of 2024, on Thursday, 7th August 2025 by the Senate of Kenya. Number two, to register our deepest concern with the conduct of the Senate of Kenya in the process of leading to the passage of the said bill, and in particular, the total violation of a constitutional promise of meaningful public participation. Number three, to caution both Houses of Parliament and in particular the National Assembly against receiving and acting on the tightened bill given the irredeemable flow process at the Senate. And number four, to serve notice of action including legal action to reverse the violation of should Parliament proceed to sanitize and entrench this illegality. But the bill that the Senate of Kenya passed without public participation is not only bad because of the flawed process, even though process is very important. The bill is also dangerous in spirit as it is criminal in intent. The bill that Senate passed without public participation seeks to legalize the violation of workers' rights while protecting foreign commercial and protect political interests. In summary, the bill intends to grant a permanent and eternal immunity for prosecution in Kenya for technology companies that may underpay, discriminate, harm, kill, or in any way violate the rights of their workers while operating in Kenya soil. This means that if the Senate's bill stands and becomes law, it will be illegal for tech workers to sue a tech company in Kenya, even if the company's violation has harmed them. We find this unconsumable and great derelict to duty by the Senate of Kenya.
Allow us to share a brief context and chronology to this matter. On 27th March 2025, upon the bill being sent to the Standing Committee on Trade, Industrialization and Tourism, tech workers wrote formally to the Senate requesting for a meeting to make submissions and representations on the bill. This request was ignored completely by the Senate. On 1st April, Senate invited members of the public to submit memoranda on the bill. Tech workers organized themselves and submitted various memoranda to the Senate on 15th April 2025. A total of 4 memoranda from various tech worker groups were submitted to the Senate. As you may be aware, the Senate Standing Committee on Trade, Industrialization and Tourism had a legal obligation to consider the views from the members of the public collected during public participation, and to table those views before the Senate before the second reading of the bill. We note that in breach of this legal obligation, the bill proceeded to the second reading on 29th May 2025 before and without the committee report being tabled before the House. To date, that report has never been tabled. On Thursday, 7th August this year, and having refused to consider any of the submissions made by the tech workers as critical stakeholders, senators passed the bill as it was at inception, and without any amendments whatsoever. We read mischief in this blatant violation of the law. We read possible external influence by big tech lobbyists in Nairobi. More unsettling, we read executive overreach that undermines the principles of separation of powers and interferes with the independence of the legislature. In particular, note that the conduct of the Senate aligns with what is now a very clear and loud interest of the presidency in championing the exclusive interest of foreign big tech companies without due consideration to impact on the business environment, investment, and Kenyan workers' freedom from exploitation, discrimination, and inhuman treatment. We recall that on 9th December 2024, long before the legislative process had begun, the President admitted publicly at a town hall meeting in Nairobi that following lobbying by top executives of a technology firm that had been sued in Kenyan courts for human rights violations in Kenya, he was changing the law so that no technology company would ever be sued by anyone in Kenya. And I quote, "Those people there," that was in reference to Samasos, "were taken to court and they had real trouble. They really bothered me. Now I can report to you that we have changed the law, so nobody will take you to court again on any matter." End of quote. Subsequently, as tech workers and the broader community of practice, we are deeply concerned with the disproportionate power and influence that technology companies seems to wield on the presidency and by extension on Senate as an independent legislative arm of government. We are deeply concerned that in passing the Business Laws Amendment Bill of 2024, rather than protect workers and ensure equal opportunity through decent work, the Senate of Kenya has chosen to side with corporate foreign interests. This legislation endorses and deepens worker vulnerability and exploitation. It tears apart hard-fought gains in human rights-centered labor relations. It weakens collective bargaining power. It undermines fair pay and strips away safety protections that have traditionally balanced the interests of labor and capital. In the final analysis, this bill is not just bad legislation in both process and substantive content. This bill is an unjustified betrayal by the Senate and the senators who have turned their backs on Kenyans, turned their backs on the Constitution, and turned their backs on the thousands of qualified, hardworking, but vulnerable tech workers. Senators have written and passed a law that gives foreign companies a free hand to arbitrarily cut salaries, extend working hours without fair compensation, detain workers in unfavorable working conditions, and erode job security. And there is nothing an employee can do in Kenyan courts. The bill sets a terrible precedent that must not be allowed to stand. Subsequently, we wish to state as follows. Let it be clear to all that all tech workers stand unequivocally opposed to the bill in its entirety, in the process, in the content, in its spirit, and in its intent. Secondly, we believe that tech companies and digital jobs provide immense opportunity for economic empowerment for many educated and qualified Kenyans. We also believe that such jobs must not come at the expense of human dignity, fair labor practices, and basic human rights. No company or corporation, however important or big, should be exempted from the rule of law in their country of operation. Thirdly, we urge tech companies to avoid the unsustainable and risky path of over-reliance on temporary political patronage and instead focus on building compliance with local laws and sustainable, meaningful relationships with workers and communities. Fourth, we urge the National Assembly to reject and/or disregard the bill from the Senate and not to waste its time to debate and consider the flawed Senate bill. Fifth, we retain the right to challenge this bill in its entirety and will do so in every forum and platform available to us in Kenya and everywhere else across the globe to draw attention to this emerging trend of legislative capture. Sixth, we have instructed our various legal teams to review every small detail of the process for non-compliance and to analyze every clause in the unfortunate bill for violation of the Constitution of Kenya. In the coming days, and in the absence of satisfactory redemptive action by Parliament, we look forward to challenging the same in our competent courts. Finally, we call on all tech workers and our allies to stay vigilant and to be prepared to act in solidarity in defense of our right to decent jobs. Organize, don't agonize. We thank you for coming.